MCSN here. The list of members submitted does not show signed consent of at least 100 members as required by the regulations.
So the list they submitted did not include consent of the members?
Did not include signed consent of at least 100 members as required, under the regulation.
So it doesn't include signed consent?
Yes.
Of the 100 members at least?
As required.
Okay,
under
go ahead.
Correct. The provision of Article 6B of the Articles of Association, which stipulates that an associate member shall only be entitled to receive notice of and attend meetings, but shall not be entitled to vote at such meetings, is contrary to Regulation 5(1) of the Collective Management Organization Regulations, as the article discriminates against a class of members in terms of voting rights.
So what does that mean?
I'll ask one of my members to explain it. What does that mean?
Your mic.
Yeah, these are the technical experts.
Yeah, please, this is very critical. We are asking you, and this moment is critical, we are asking you to tell us your requirements for granting license. And we are asking you at the same time to tell us, because if you have the law, if you have the benefit of the law, and you do not exercise that right, as somebody is saying, so we want to assure ourselves that you did comply with the law. If you don't, then something happens. So this is an opportunity. You have told us the regulations. So what infractions, what specific? We have no interest, as I said. I'm not a musician, although I want, because if I'm no longer a politician, I have something like that will be coming into me I have a husky voice, so I can never.
Before I further expatiate on the particulars that the Director General has said, I'd like to say that in considering the application, 3 basic parameters were set. The first parameter was compliance with the provisions of the law, which the DG has read the provisions of the law that needed to be complied with. The second parameter was to look at the internal organs of the applicant to ensure that it provided for a fair playing field, a transparent management, and accountability. The third parameter that was also adopted was to ensure that the interests of Nigerian creators were duly protected. These were things that had to be looked at in the internal rules of the applicant. And when the internal rules of MCSN was looked at, some of this...
Before we go to internal rule, you specified 3 things.
Yes.
Compliance with the law,
yes,
internal organ, and then whether interest of... Now let's deal with the law. What section of the law or regulations did they not comply with before we go to internal?
As the DG has pointed out...
No, he hasn't pointed out anything. Okay. He only said they did not sign...
The provision of Regulation 1 sub 2E
what does that say? What does it say?
Requiring the submission of a list of 100 members.
Okay, so we have it on record that one thing they did not comply
yes.
with is the submission of record, signed document of authority giving them authority
yes.
to. Okay, so we got that. So that's the...
Yes. Now, with respect to the articles of association they submitted.
Yes.
Article 6B of their articles of association was in direct violation of Regulation 5 sub 1 of the collective management regulations.
Well, what does 5.1 say?
Regulation 5 sub 1 provides each member of a collective management organization shall be entitled to 1 vote with similar rights and privileges. And their articles provided categories of members, some of which did not have voting rights. And we thought this created an imbalance.
Okay, so the law says 1 man, 1 vote.
1 man, 1 vote.
And their own article says...
Some people will be entitled to receive notice and attend meetings, but they will not vote.
Okay. No, let him continue, please. Let him continue.
Article 35, sub 1, 2, and 3 of the articles. I must mention here that the composition of MCSN also has institutional members. two of which are foreign companies, the PRS of London and the MCPS of London. This article granted these two bodies enhanced privilege to appoint members of the board as opposed to others who needed to be voted in. And we thought this created an unfair playing ground, an enhanced privilege to a foreign body over Nigerian interest in this society. Now, the provisions of Article 8B of the Articles of Association of MCSN also was contrary to paragraph 4, sub 2 of the regulations, of our regulations. If I may read what paragraph 4 sub 2 says. Paragraph 4 sub 2 of the regulation says, a collective management organization shall not impose conditions requiring a member to constitute the organization as a sole collecting agent or as agent for any other purpose otherwise than for the purpose of managing the rights of the members within the scope of the organization's license under these regulations. The articles in question seem to have created a cloak on the right of members to be able to operate freely. Outside the issue of the articles, when we carried out an audit of the repertoire of MCSN, and we actually did interview them, the form they fill and the inspection we conducted in their offices also indicated that MCSN at the time had 90% of the foreign repertoire as opposed to 10% of Nigerian works. And when we looked at it carefully, the implication of this to the assessment committee was that when royalties are collected from Nigerian businesses, these royalties will be paid outside, and that this will not be in the interest of Nigerian creators. These are some of the reasons that informed the denial of application of MCSN.
Yeah, that is just one. You say one. This is just one about their internal organ. Oh, yes. These ones are internal.
Yes, I've talked about that.
Okay, so what legal requirement authorize you to go to the internal? Because that's not in your regulations. It's not on the law, and it's not.
It is in the regulations. Section 39 empowers us to make the regulations creating conditions.
Yeah, and so what condition, this 90% and 10%, what regulation did it offend?
Mr. Chairman, I had earlier said that the conditions we set for approving them included overall national interest.
And what section of the regulation contains national interest? I just want to get you clear.
The totality of the regulation is made with the philosophy to protect Nigerian right owners.
What section?
Not specific
What
provision.
section?
No,
what is your name? What section? A simple question.
Mr. Chairman, all the sections.
Can you tell me your name?
My name is.
And your. I mean, I'm asking you. Tell me your name and your status on NCC.
My name is Michael Akpan. I am currently the head of the regulatory department, which is in charge of regulating issues of collective management.
Do you have a specific section in the regulation that empowers you to subject application to the overall interest of Nigeria? And if you have, cite it. If you don't, let's go further.
There is no such particular.
Fine. Okay, go ahead.
No such particular provision,
That's it.
Mr. Chairman.
Yes, please.
Sorry, sir. In as much as I don't subscribe to the issues he's raising, I don't think there is anything wrong for an organization of Nigeria to protect the interests of Nigeria and Nigerians. I don't think there's anything wrong, so long as it's done in good faith. Again, Mr. Chairman, I think that this issue of internal regulation could be used to wish hunt any organization, because it's like a blank check. If I don't like your face, I will now bring one clause and call it internal regulation to deprive organization.
Okay.
Yes. So I think that, yes, sorry, sir. So to round up, sir, I think that there is nothing wrong if an organization is poised to protect the interests of Nigerians and Nigeria, but so long as it's done in good faith.
Chairman Judiciary.
Thank you very much, Mr. Chairman. And I want to thank members of this committee. My name is Chief Tony Okoroji. I'm Chairman, Copyright Society of Nigeria. Because beyond the issue of collective management, what we are witnessing goes to a lot of issues that affect our country and how decisions are made. I represent over 2,000 members of COSAN. If they were to come here, we'll take every seat available here today. I listened very attentively to the submission made by Chief Raymond Dokpesi, and I was alarmed. Mr. Chairman, when you made your opening remarks, one of the things you said was that MCSN was incorporated in the year 1994. 1984, in fact, in the year 1984. In other words, MCSN will be 30 years old next year. I have been a major representative of the music industry in Nigeria. I was president of PMAN for 6 years. And I know that this issue has been one issue at the neck of everybody. And if in 30 years MCSN was effective, there would have been no need for a COSAN, no need for new approvals, and no need for the hearing we are having here today. The other matter I need to bring to the attention of this committee is that this is not the first hearing by a committee of the House of Representatives. There was indeed a hearing in 2005 by a committee of this House of Culture and Tourism headed by Honorable Araka. You know, the likes of Colonel Tuda Akugu was here, I was here, and these issues that we're discussing were discussed in detail. Even before that, there was a time that MCSN brought a recommendation seeking for a bill to scrap the Nigerian Copyright Commission. If you check, the records are here. The point I make is that COSAN was 3 years old 10 days ago, the 20th of May 2013. COSAN was approved on the 20th of May 2010. What is the situation? Before that, the likes of Chief Roman Dokpesi and AIT and Ray Power paid no royalties to anybody. In fact, no broadcast station in Nigeria was paying royalties. Artists had nothing from them. For 40 years, the broadcasting organizations in Nigeria have just rolled the can, found one reason or another to continue to use the intellectual property belonging to Nigerians without paying them a penny. I have attended meetings and meetings of broadcasting organizations of Nigeria where the artists were seen as the hewers of wood and the fetchers of water, and their rights were trampled upon over and over again. 3 years ago, COSAN was approved. A year after, COSON distributed, for the first time in the history of Nigeria, 25.7 million to stakeholders. In December last year, COSON distributed 100 million naira to stakeholders. And we believe that if we stop the process of the troublemaking that's going on, COSON can be a major force, to help the Nigerian music industry do what it ought to do for the musicians in Nigeria. I come here asking, yes, the issue of monopoly, which the chairman has rightly addressed. What is the trend? The first thing that everybody on this table must understand is that COSON is not a business organization. Under our law, it is registered, and it must be registered as a company limited by guarantee. There are no shareholders, there are no shares, it does not declare profit, it makes no money. It's like a trust. The same way the MBA is a monopoly. Any lawyer here knows that the MBA is a monopoly. It's a monopoly, and it's allowed in Nigeria. The NMA is a monopoly, it's allowed in Nigeria. The NUJ is a monopoly, it's allowed in Nigeria. PMAN, of which I was president, and some of the people here belong to, is a monopoly. It's allowed in Nigeria because it's not a business enterprise. COSON is not a business enterprise. It collects royalties and distributes, it makes no profit, it declares no profits. And what is the trend everywhere in the world? I go to our sister nation, Ghana. Ghana has an organization called GAMRO. GAMRO is a monopoly. There is no other organization collecting or distributing royalties for the music industry in Ghana except GAMRO. You go to Togo, or go to Benin, or go to practically everywhere in the world except maybe the United States of America and Brazil for these same rights that monopolies. In Canada, and I say these things because with all due respect and all humility, I represent these issues around the world. Next week, I'm going to be in Washington, D.C. discussing this with collective management organizations around the world. After that, I'll be in Norway teaching this subject. I've written a major book, which I hope I will circulate to you people. So Nigeria has experts in this area, and we do not need to be running around the bush. But what are the practical problems? I can understand people who say liberalize collective management, but you go through history. Collective management is not that kind of situation where you can say open liberalization. It's not like MTN, Glo, Airtel, and all that. It works on the principle of the that's why it's called collective management. The bigness of the power that we have. The organization we represents the musicians of Nigeria. There might be a few people who are not there. And you cannot create a collective management organization for anybody who says, I don't belong. Which means that if somebody says, I'm not going to belong to COSON, I'm not going to belong to MCSN, you collect a third, you approve a third one, and then you approve a fourth one, and you approve a fifth one. And they all go to broadcasting stations, all of them, and say we want to collect royalties. You are creating chaos. It will not work. And when we had more than one collective management organization in Nigeria, it did not work, sir. It did not work. Collective management.
Was there a time we had to?
Yes, we had an organization called MCSN and PMRS. It did not work. Sir, it did not work. Why? I can explain to you why. It gave the users every opportunity to say, we will not pay. We don't know who to pay to. Go and sort out your house.
Oh, but I thought, listen.
Yes.
I thought if there is PMRS, COSON, and there is a musician, you cannot register to the two. You register to one, unless if there is...
You are correct, sir. But the reality is that a lot of musicians were in both of them.
Oh, okay.
That is the reality. Chief Dokwesi, who spoke here, right? His station was saying, you guys go and sort out your problem. Okay. We want to know who to pay to. Now he has turned around, in a practical, fantastic divide and rule tactics. I'll explain to you. Today in Nigeria, Wazobia FM is paying royalties. Cool FM is paying royalties. Nigerian Info is paying royalties. Today in Nigeria, Silverbird is paying royalties. Beat FM is paying royalties. Classic FM is paying royalties. Multi-Choice is paying royalties. All the mini stations are paying royalties. FRCN, owned by the Federal Republic of Nigeria, is owning royalties. NTA is paying royalties. AIT does not pay royalties. AIT does not want to pay royalties. AIT wants to divide us so that we can fight against each other. There is nobody here who is being discriminated against by COSON. Nobody here has applied to be a member of COSON and it was rejected. Nobody here has royalties from COSON and it was not paid to him. This is a classic case of divide and rule, and so that you can oppress the musicians of Nigeria forever and ever. This house must say no to it. This cannot continue, for God's sake. Thank you very much, sir.
Okay, thank you very much. Entitled to. On the issue of the hearing of 2005, yes. I want to assure you that Nigeria has made a lot of progress, even in the executive, and even more progress in the legislature. This is the 7th Assembly, and the 7th Assembly is very, very different. I don't know whether we should take his question or go to MC. I think maybe what? They are saying we should just take the other, so that we have the two stories together.
Honorable Chairman, sir. Yes, Honorable Chairman and Honorable members of these joint committees. We thank you very much for this opportunity you have given to us this afternoon. Most of the things I want to say. Well, my name is Mayowa Ayilaron. Mayowa Ayilaron, the Chief Executive Officer of the Musical Copyright Society, MCSM. First, I want to mention the fact, I will take it from the issue mentioned here by Chief Dokwesi, that the issue of forcing a monopoly on the industry smacks of internal abuse or abuse of offices by some officers of the NCC. And this is contained in our submission to the House. And I will refer the House to our Annexure 3 with the names of some of these officers of the NCC. Chief, yes, Annexure 3. Mr. Chairman, I'm sorry we didn't have enough time to number the pages. The first annexure is the evidence of MCSN approval by the Attorney General of the Federation, then followed by the list of MCSN members as at 28th May 2010. Then immediately after that list is Annexure 3.
Yes, after the list.
After the list.
Yes.
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 Exactly, sir. Yes.
Right after the list.
Right after the list. Yes, ma'am. Yes. That list is a letter sent to MCSN way back in 1997 by the international organization known as International Confederation of Societies of Authors and Composers. It was the PMRS then, which was suddenly registered after the NCC first turned down our application, applied to join CISAC. In fact, the application to join CISAC was originally written to CISAC by the Director General of the NCC, Mr. Moses Epo. The first application to join that international body is like joining FIFA. Was written, the application was made by Mr. Moses Epo to CISAC. Then the CISAC now wrote back to Mr. Epo that he should allow the society itself make the application. And when CISAC received the application, because we are also a member of CISAC, they forwarded the file to MCSA for comments. And by the time we went through the list of the directors, we found out that these members, these directors of NCC then, on the board of NCC, were also the people who incorporated and formed COSON. I mean, the name includes Chief Mrs. Keji Okunowo, Chief Tony Okoroji, and Chief Ebenezer Obey. Then the officials who were running the operations of PMRS include the following NCC officials. One, Mr. Bayo Ayebusi, who held the post of acting general manager of PMRS, and he was a senior officer. They were busy destroying MCSN after their relationship from MCSN and imploring them to join or to assign their interest to COSON or PMRS. Honorable Chairman, sir, if you go to Annexure 18 of our submission, you will see a letter written by the current Director General of the NCC towards the end. Annexure 18. This is a letter written by the NCC advising the CISAC to sever its relationship with MCSN and transfer same to COSON. So what I mean is that they were using their official positions to destroy MCSN.
But don't you think that to them you are operating outside of the law and they are saying, look, you should not.
Yes, sir. Honorable Chairman, sir, that is their own opinion. And this is the position they have presented before the court.
So it's he said, she said. Okay, we'll look at it. Go ahead.
They cannot sit in their chamber and be interpreting the judgment of the court. Yeah. There is a judgment to that effect. Okay. So the court has ruled that MCSN operation is constitutional and legal. That was the latest. Yeah,
but that was before the coming into effect of the NCC.
No,
law.
This is a March 18 decision.
Yes.
2013.
Yes. Are you aware of the decision? They are not aware of the decision. Do you have a copy of the decision?
The copy is there as Annexure 15.
What did the court say, please? Annexure 15.
Yes.
What did the court say?
These are the orders.
No, what did the court say?
Yes, that I will read the.
You've read it. Just tell us. We will read it also. Okay. We will read it.
It says
just what
the operations and the existence of MCSN is constitutional and legal.
Because so held.
Yes.
Okay, we'll look at it.
Yes, sir.
Okay, go ahead.
So, with all this, the NCC officials were only trying to protect their interests by trying to enforce COSON as the sole organization. And we have also annexed here, sir, in response to NCC claim that we did not fulfill the regulations. Yes. This is the application we submitted. Sir, this is the copy of the application we submitted to NCC on 22nd July 2009, as at which date COSON was not in existence. As soon as they received our application, they announced the shifting of the deadline to the end of the year in order to accommodate whatever they are cooking.
Yeah, but they have the powers under the law.
Yes, they have the power, but they are doing it deliberately with the aim of legislating us out of existence. So when they came...
Yeah, but...
Yes,
okay.
Yes, sir.
Well, if you submit any evidence towards that, but
yes,
go ahead.
They claim that our submission, our application was not complete. This is the acknowledgement duly stamped and signed and commented upon by the relevant NCC officials. And these are the documents submitted, and they ticked: 1, certificate of registration; 2, memorandum of association; 3, articles of association; 4, membership; 5, particulars of directors; 6, affidavit of...
Did your article of association mention that did it go against the one-man, one-vote?
No. When you enter into an organization, there is what we call incubation period. There are some authors, some composers who have not even released any work or whose work are not in the commercial realm. So they are there when their work will start to earn royalties. We don't go into the street to just put any names on our membership list. We look at the quality of their work is your work being exploited? Can he earn money for you? So if you do not have, it's like somebody who does not have a share in a company, wanting to vote in that company.
What about the fact that the 100 members you submitted, you didn't include their signature?
If you look at the annexure, there are lists that we submitted with signatures of this paper.
The question is, did you submit it with your application?
Yes, this is it. We have more than 1,000 members. We also included signed deed of assignment. And we also included the reciprocal contract between us and some of our international affiliates to show that these rights were actually...
What is the percentage, if I can ask, what is the percentage of your membership? No, Nigerian.
Yes.
How many musicians
do you have? We have not less than 90% of Nigerian musicians in our membership as at that date.
That 90% is no more than 10% of the foreign, because they say you have 90% foreign and 10% Nigeria. So that 10% Nigeria is 90% of the Nigerian musicians. Is that what you're saying?
Let me explain, Mr. Chairman. You have a pot, a repertoire of both national and international. By the repertoire that we have been able to acquire from all over the world, let's say we have 1,000 works together, including that of Nigeria. When you now compare the ratio of Nigerian membership within the larger international membership, it's like when we say, what is the world population? And Nigeria has about 150 million. And somebody is now saying, because we are only 2% of the world population, we are not protecting Nigerians. No. So there is no way. What we are saying is that the repertoire of music being consumed in this country, we have the majority.
Okay.
And we do not segregate.
Can you round up?
Yes, Mr. Honorable Chairman, sir.
Because my colleagues have questions for you and Mr. Okoro.
Yes, sir. So, Honorable Chairman, sir, to round up, we also annexed. They were trying to deceive this House by presenting COSON as a brand new organization newly formed. That is far from the truth. They only went to the Corporate Affairs Commission and simply changed the name of PMRS to COSON, maintaining the whole structure. And when they wanted to deceive the whole country, they now announced to the world that COSON has collapsed its operation PMRS has collapsed its operation into COSON, which is not the truth. It is still the same PMRS, the same set of people that were running through the PMRS. So thank you, Honorable Chairman. All we are saying here is that we have tried our best. We voluntarily made this application to NCC. If we don't want them to regulate us, we wouldn't have made application to them. There was no point in time they said, Tom, this application is short of this. Why don't you do this?
Thank you. Let me quickly go to Ms.
He said you did not apply. According to their rules, you have to apply for reasons why you are not registered. So did you apply to the NCC?
Honorable Chairman, sir, they refused us approval on 28th July. 28th May. The same day, there appeared in the newspaper a public notice declaring us illegal, with threats to arrest and charge us to court. So they have already made up their mind. Yes, the same day.
You have copy.
We will get the copy for you.
We have to have a finding of fact on that.
Yes.
On the same day you.
So they didn't even give us any chance of dialoguing with them. And they have been persecuting us right from 1992, writing to people all around. Even, Honorable Chairman, I just want to make this point. Chief Okoroji was making reference that some people were paying royalties, or people were not paying royalties before now. In 1988, the bond were negotiating with MCSL during the lifetime of the late DG of FRCN. It was this Chief Okoroji who wrote to Bond then, as the president of PMAN, that they have not allowed MCSL. And from then, he has been causing all this problem. or confusion within the system. So he cannot come here today to deceive the nation that PMRS or COSON is performing when they were employing the force of government.
All right, let's listen to Mr. Onyeka Owenu. Perhaps because the Chief Justice of Nigeria is a lady, and at law, we refer to her as a man. There is no female in, and she is top there. So
it is well. I stand behind established protocols to cut the time short. I would like to present a different and separate perspective on what is going on here. Everything that has come out is legitimate for whatever reasons, but I think it's important for you to know the feelings of musicians regarding this unending tussle that has deprived us of earning our dues. I have been involved in this process for a very long time. I even went on a hunger strike in front of NTA because my rights were being deprived. When NTA stopped the airing of anything concerning Onyeka Owenu because I asked to be paid my residual dues. I have so much at stake. It's all about individuals, really. And if NCC should be an honest broker, they would admit that a lot of the reasons they've given for not registering MCSN could apply to COSON right now. The use of more than 30% of its income for administrative purposes, they know is going on in COSON and has gone on for a long time. COSON, as it is constituted and as it is being run as an organization, is about one person, Tony Okoroji. And this is the problem that we have. As chairman of the board, he also acts as the substantive MD. I know because I have straddled both organizations. I have served in MCSN as a director of the board. I'm not here to side anyone. They have their own issues, and they know that I've always, from day one, talked about those issues. I have been a member of the board of PMRS, which metamorphosed into COSON, and I know the issues very well indeed. When an organization which should be run for all its members one man becomes the issue, you are going to alienate people. Some of us who were on the board, because we came against some of the fiscal practices that we did not agree with, and we were constantly putting it on the front burner. We were ostracized. An election which was not fair was held, and people like me were removed with the supervision of the NCC. And we were, yes, the NCC supervised the elections. Oh, no, it was not a true election, but it's a matter that is in court. So I will not say much about it. But this is the situation. People like me were removed from COSON because we would not abide some of the practices that were going on. A situation where the chairman of the board has a company that undertakes contracts for COSON is wrong, and others are not given the opportunity.
Why didn't you report that to the regulator?
They were aware because they send their members to all our meetings. They are represented, and they are all aware of this issue because these issues were raised on the board of COSON, and they know about it. It got to a point where it became unbearable, really, and they watched while it all happened and did nothing. Sir, we have a situation in COSON where most of the people who are supposedly members are not musicians. Last year, when an election was coming on and there was politics to be played, people were registered as members. Now, normally when you register as a member, you would earn nothing that year. It's the following year that you become eligible for dues. But last year, suddenly, those people who were brought on to sway the elections were paid large sums of money. And so some of us cannot even come and speak up at meetings. We will be shouted down because there is serious politics going on there. There's a large sums of money at stake. I urge this House to look into the constitution of COSON, why the chairman does not have an end to his term. He can be chairman for the rest of his life. I would like this committee to look into fiscal matters in COSON and find out what's going on and the membership structure of COSON.
I would have said I don't have any question with you. I will only ask the NCC to tell this committee why we should not rely on patients and she appears. So you will have a burden to tell us why we should not rely on all that she said. But one question I have to ask you before we go back to the two organizations is that as a musician, as a professional yourself, what would your dream be? Would you want a monopoly, or would you want competition?
To be honest, there are arguments to sway. It was ideal to me to have one collecting society because you would avoid situations where there are these same struggles, we don't know who to pay to, and the conflicts would be lessened. However, there are areas where COSON does not cover, and those areas remain uncovered. There are also the issue that you have NCSN. NCSN has a right to manage those artists, to manage their rights, who have signed on to them. And really, if we can organize this in such a way that the rights are divided and well managed, and more than one can be registered, if anything, to end this merry-go-round for people who do not want to pay.
Good for the a very brief one, DG. Would you areas that COSON is not covering for another one to come on board? Is there just a simple answer?
Have any problem at all whatsoever?
Okay, so my colleagues have questions for, please.
Chairman stroke MD
Please.
was making a submission.
Sorry.
Okay.
Please, do write your question.
He provided an information as it relates to other countries with specific to Canada. And he said Canada has one. If I give you this,
He said Ghana.
Oh, he said Ghana. He said Canada? Ghana. Oh, he said Ghana. I heard Canada. I heard Canada. What I wanted to do is for him to look at the list of collecting societies from Canada. There are more than 15. So if you can look at them, then you can respond. That is my question. If that is correct, that they have more than one. Okay, so no, I'm talking about what I've seen, please. This is from this side, not from your side. From this side, if you look at under Canada, if they contradict in any form, you let the House the committee know.
Yeah, thank you, Chairman. My question clarification. When when you were asking the question, the attachment 3 you mentioned, where NCC, they have their members who were acting in companies that they are supposed to be regulating. One is, I would like NCC to affirm that that is the case. 2, does that offend the law? We want to know whether that offends the law. Apparently, when you want to come to equity, you come with clean hands. And there is apparent conflict of interest. So does that offend the law? And if it does offend the law, which law? And is it you're thinking that that would not guarantee your interest? 2 is, I want to know whether it's been mentioned here, but it appears from what Onyeka said that the organizational or the administrative tendencies in Kusun is what is occasioning this. And I would also want to know whether if these things are cured, the administrative challenges or restructuring is done, whether it will be disposed to be part of Kusun or have a better enlarged body. Thank you.
Honorable Kwemi.
Thank you, Honorable Chairman. Mine will be both comments and questions. I listened to Kusun's presentation from Chief Tony Okoroji. To begin with, I'm totally opposed to monopoly. And I believe trying to liken Kusun to organizations like the Nigerian Bar Association, NUJ, and all that, I mean, it's totally out of context. Because Nigerian Bar Association is there to regulate the affairs of members of that body of professionals. You know, and when we're talking about a collecting body, to begin with, we are talking about intellectual property rights of people. And if we're talking about, and attached to that also is their right to freedom of association, except where the law says